So I can tell that, or like I mentioned in the first civil litigation session that we had, was that one of the civil litigation is one of those courses that it is easy to pass. It's very easy to have an A, to be very honest, and that is because it's the one that has, like, the draft, right? Though I won't lie, the draft in civil litigation are a bit much, but it is one of the courses that once you get your draft, there's always a draft in every question, or there are drafts in from compulsory to, and the moment you know the answer to a question, you probably know the draft, because many times you see question as, oh yeah, what is the if you answer question A, if they ask you what is the process, you say what the process is. So B will be like, oh yeah, draft the process. C can be like, oh, if your answer is in another jurisdiction, will your answer be different, yes or no? D can then be, oh, draft the process. So it's very one point that is very easy to get a full mark. Unlike corporate, that it is more of procedures, right? The only draft in corporate is either you're drafting your memo or you're drafting notice of meeting or resolution, and really that's all. Every other thing you do in corporate is majorly procedures, and procedures are like, you don't know it. So one act that I had a senior, I think Ewa also knows him. He finished first class from law school, and one thing that he told me there before going to law school is, if you can do any drafts, know your draft is one of the easiest way to pass, and one of the ways to get like full mark in any questions. So I really try to do that. So that's one thing about civil litigation. As much as it can be bulky, I'm not gonna lie, but one easy way out of it is draft. Now, so for the purpose of election petition, majority of the things that few things that you need to note will also be the things that will also determine your draft, because if you say you have a pre-election matter and they tell you to draft the process, and you're drafting it in, let's say, Court of Appeal or Election Tribunal, then that's where there's the issue, because there's a different jurisdiction for pre-election matters, and there's a court that has jurisdiction on election matters itself. Faye, please, in case you do not hear me, I know I sometimes speak fast. If you're not catching me, you can please call my attention so that I will slow down, or if you cannot hear me in between, for whatever reason. Thank you. Now, for election petition, the applicable laws, the general principle is election petition is sui generis. It is more or less like fundamental human rights. They are special procedures. They have their own rules. They are guided by their rules. They stand on their own, right? And another thing that you should note for the purpose of bar finals, more particularly for your MCQ, as well as in case you are drafting, in case you are going to take an election petition question. And I think that this is this is a common thing across all courses, not only civil litigation, is that when you are drafting, pay attention to the dates in your questions. If your question should give you a date, please always pay attention to it, because of every other thing. I don't know if you were here. I think you were here last week when we treated recovery of premises, and there's that rule of notice to quit is 6 months, when I was talking about when you must calculate your dates. Law school will not just assume. If they don't give you a question, they don't give you a date in the question, it is assumed that you use the date of your exam to prepare it, and you do your calculation in between. Same thing if you're drafting your notice of meeting, they might just give you a date of the meeting in your question, but when you're drafting your notice of meeting, you have to count the number of days. If it's a special notice, you are counting, I think, 21 or 27 days. If you are with special notice, 27 days. If it's a normal notice, you're counting your 21 days. You must count it backward to include the date, which is another thing. It's very important if you are doing election petition, both for purpose of MCQ and purpose of your bar finals, your theory exams. If you are drafting it, you need to pay attention because of the number of days. Now, because election petition is sui generis, time is of essence, right? Time must be complied with. Like, you cannot skip it for whatever reason, right? You must adhere to the time. It's not like, unlike other processes whereby you can come and be filing notice of extension to, like when we treated appeal and we are saying, oh, you can go on and be filing your notice of your extension of time and all those stuffs. They are really, really, really very, very conversant and very particular with timing when it comes to election petition. Say for instance, one key thing to note is that the election tribunal must be constituted not later than 14 days before the day of the election, right? And your days of election, an election petition must be filed within 21 days after the date of the declaration of the result of the election, right? Because there's no extension of time, and once a petitioner fails to file his petition within that 21 days, he is statute barred. Not like I said earlier, it's not like appeal that you can go and be filing Trinity prayer and be doing notice of extension to file, notice of extension to do, every other thing in between, and the judgment must be within 120 days, right? And where there's an appeal from the decision of a court of tribunal, it must be heard and disposed of within 60 days from the date of delivery of the judgment of the tribunal court, meaning that within that 60 days after judgment, you must file, the court must hear, they must count the number of days and do their
Sorry.
Yeah.
You said it must be filed within 21 days after
declaration of results.
Okay.
Now, it is important. So, why I also said it is important to note declaration of results, not the date the election is holding. Say for instance, I think I remember there was a particular past question, I've forgotten the year. I think the election spilled into like the other day. So election was, I think the question said election was like on a day. Let's say election was held on the 21st, but result was not declared until 23rd. The valid date is not the date of election. It is the date that the result was declared. Say for instance, in Nigeria now, we know that most times, previously, I think until this last election, that election results were easily collated because of, I think, their server, whatever. Before, it used to be a thing whereby, I think it was still that, whereby after collating it, every local government, every ward, they will give it to the person in charge of the state. The person in charge of the state will transport it to the central place where they are reading it in Abuja, and they'll be calling them one after the other because it takes days. I think then they used to use all these chancellors used to be the ones to do it. Chancellors of states, right? I think it happened during Jonathan election and all that. So what they do then is, in my election might hold, let's say today, they might use 5 days to read it because all of them have to transport themselves. So if the reading is done in Abuja, those that did everything in Maiduguri will travel down to Abuja with the paper sheets that they've counted, they've recorded, then they will transport it one after the other. So in that instance, you can't use the date of the election. It's the date that if it was declared a week after, is that 1 week after date that is valid. This is also very important because if you are dating your petition, for instance, so you don't use the date, you have to calculate, you have to look at, you have to be wary of the date of declaration of results, right? So that is why I said 21 days. Is that clear enough? Hi, Faye. Is it clear?
Yes, it is.
Okay, thank you. Right. So it has to be within that 21 days. 21 days is the strict limit. If you breach it, you cannot go and be doing extension of time, whatever. That's all. And once the election tribunal is concluded, from the dates of the filing. Now, also for election petition, it is not the date that you hear the matter. From the date the petition was filed to the date the judgment must be given has to be 120 days, not the date that the tribunal heard the petition. Same example, you file your election petition today. You file your petition today. The 180 days starts counting from today, not the date that the tribunal gives you for hearing, not the dates that. So if they like, let them use 1 week to hear one party, and a whole month to hear all those, each respondent or each applicant, as the case may be. They have total of 180 days from the date of filing. This is also important because I remember, I think my bar finals, it came out this number of days, and I remember say 180 days from date of filing, 180 days from date of declaration of results, 180 days from the date of election. So you have to pay attention to what it is. The first one is 21 days. So first number of days is tribunal. Tribunal must be constituted not later than 14 days before the day of the election. Petition must be filed within 21 days after the date of declaration of results. The tribunal must give their judgments within 180 days from the date of filing of the election petition. Now, where there's now an appeal, right? The appeal, everything also must be done within 60 days. Okay, Faye, your question. I can see your hands are raised. But your hand is raised.
I didn't get that part where you said tribunal must be constituted. So within 14 days?
Not later than 14 days before the date of the election. So it means that before the date of the election, 14 days backward at least. It can be more than, but at least there must be a 14 days gap between the date of the election and the date the election tribunal was constituted.
I don't understand.
So let's say election is coming up on the 15th of August, right? It means that at the very least by 2nd of August the election tribunal must have been constituted. If you constitute the tribunal on the 3rd of August or the 4th of August, that constitution is not valid by law.
Or is the tribunal not supposed to be the one to hear about validity of matter or people that were elected? So if they are being constituted between the date of the election and you said the date of what again?
14 days before the day of election.
Okay, I thought you said between the day of election.
No.
And another date.
No, 14 days
just before the date of election.
Yes, not later than 14 days before the day of election.
So they will be constituted.
Yes.
For hearing of any election petition.
Yes.
So from the date of filing, 180 days, they have 180 days to give their judgment. Yes.
From the date of filing of the petition, meaning that the moment you file, they have 180 days to hear the petition and to give judgment within 180 days from the date that the petition was filed.
Okay.
Is that clear?
Yeah.
Now, for the election tribunal is 180 days. If there's an appeal from the tribunal, it is 60 days. Right? It is 60 days from that. Those are the number of days that's very important for you to note of. And we all know that election tribunal, the court, for some instances, that the court of appeal is the first court, is still known as election tribunal, even if you know it's a court of appeal. It is still typically like presidential election, governorship election starts from the for president, for office of president and vice president, and it is exclusive. It starts from the court of appeal straight up to the Supreme Court, right? For governorship used to have there used to be a governorship election tribunal. So the ones that court of appeal is straight up first court of instance, that is known as the tribunal, is the president and the vice president's position or their election, as the case may be. Right, so that was one. The applicable laws Those one are something that you can. We have the Electoral Acts, the Constitution, and the rules, and the electoral the guideline, and Federal High Court rules. Federal High Court rules for the purpose of pre-election matters. Right. Now the types of election. Let's do the type before election, before jurisdiction. The basic type. There are two types of election matters. We have the pre-election matters and we have the post-election matters. Right. It is the pre-election matters I was trying to explain earlier, that the pre-election matters, the court that has jurisdiction for pre-election matters is Federal High Court. Now, not the Court of Appeal, not the Election Tribunal. By implication, when you're election tribunal, it means that the election has taken place. But for pre-election matters, it is the Federal High Court. And the common things that you see in pre-election matters are issues on nomination of candidates, sponsorship of candidates by political parties, or substitution of candidates in between. Those are what come off as pre-election matters. And post-election matters, there can only be three grounds. So post-election matters, let's just say you count it as, let's say, the grounds for election matters. That is where there's disqualification, the ground that the person who was elected should have been disqualified, or there's an invalid reason by reason of corruption or non-compliance with the electoral act or electoral guidelines. And the third one is where the person is not duly elected, as the case may be. So I pointed out this so that we'll be able to know the two distinctions between what comes under pre-election matters, what comes under post-election matters. Say, for instance, you see a question and your question is really regarding or is surrounding matter that is surrounding something that concerns this thing. Just know that it is when you see anything regarding nomination of candidates, or the candidate was not duly sponsored by a political party, because the rule must be sponsored by a political party, all those stuff, and they tell you to draft something relating to it, even if they don't tell you to draft and they just ask you to drop something relating to it, just know that it has to be what they can just ask. People question can just be which court has jurisdiction. Just know that the court that has jurisdiction is Federal High Court, right? Why every other thing goes back to Court of Appeal or Election Tribunal, as the case may be, right? So now the court that has jurisdictions regarding election matters, I've kind of mentioned it. We have the Court of Appeal. Court of Appeal is the one that hears the election petition for the office of President and Vice President. Then we have the National and State House of Assembly Election Tribunal, which means they hear election petition on anything regarding National Assembly or State House of Assembly, as the case may be, right? And for that instance, the Court of Appeal is the final court meaning that from the National or State House of Assembly Election Tribunal, if you have an appeal, it goes from the tribunal to Court of Appeal. That is final. You cannot take it to Supreme Court. Unlike that of President and Vice President, once the Court of Appeal, you are not conversant with the Court of Appeal, you can still go straight to the Supreme Court, which is the final court. However, for this National and State House of Assembly, it goes straight after that. Once there's an appeal, the Court of Appeal, it goes to Court of Appeal, and that's the end. Court of Appeal decision is final. It doesn't go to Supreme Court. By the time you are reading, you probably see things on the composition. The composition is that the chairman shall always be a judge of the High Court, and two other members that are appointed from either judges of the High Court or Qadi of Sharia court, and as the case may be, right? Then for governorship election tribunal, there is a governorship election tribunal for each state, and from there appeal goes to the court of appeal. Then from court of appeal, it can go to the Supreme Court. It means that the only tribunal that court of appeal is the final court of decision is that of the National House of Assembly tribunal or State House of Assembly tribunal, as the case may be, right? Is that fine? Can I go on before I go on to the next thing? Any questions so far?
Please repeat it. You said it's the final court of decision.
Okay, so they are basically, let's put that there are basically three courts. Let's say there are three courts that has jurisdiction.
No, I got that part. I'm just
okay.
saying, did you say final court of decision for National and State House of Assembly?
Yes, and that's court of appeal.
I got that then. It's fine.
Yes, any other one goes to Supreme Court apart from the National House of Assembly and State House of Assembly election tribunal. Right. Now, we have other things that are very then important for you to note in election tribunal, in election petition is who are the parties to, or who can be a party to an election petition. Now, typically we have the petitioner and we have the respondent, right? So then who can then qualify to be the petitioner? It means that there can only be two types of petitioner. It is either the candidate in an election or the political party or a political party that participated in the election. We cannot have interested party being a petitioner in an election petition, right? We cannot have an interested party. It means that for you to be a petitioner, you must either be a candidate that participated in the election or a political party that participated in the election. If the candidate refuse, say for instance, I'm a member of AMPP, for instance, and I lose an election, and I can tell them that I don't want to petition, I don't want to do anything, I'm fine with the outcome. AMPP can go ahead to file the petition because it is a political party that participated. There can be a petitioner standalone. Do you get? Anybody other than that, other than a political party that participated, say for instance, I think there was a time whereby there were issues whereby some political parties said that they were excluded from ballot paper and every other thing. Those matters are pre-election matters. Well, it should be pre-election matters, but anyways, that's the end of it. They cannot file election petition to say that the election was not duly considered because they did not even participate in the election. Their name is not on the ballot and nothing other thing. That one they are ousted, right? Then who can then be a respondent? A respondent can either be a person whose election is complained of, that is the person that won the election, or the political party whose candidates won the election, and INEC office and INEC generally. So under the INEC, you can then see where the election was, where it relates to governor or deputy governor. You can see maybe the chief electoral officer instead of INEC itself. But when it comes to like the federal or like presidential election, is mostly the respondents. That's why most times if you see a draft of election petition, you always see, or you see a normal election petition matters, you always see that the respondents are, there are only like 3-4 respondents. You see the person that won, the political party that won. You see them, they will tag INEC. They will also sue INEC, add them as respondent, and sometimes sue maybe the returning officer, the person that collected the results, and all those stuff. Maybe because of the conduct, they would, always tag those ones because those are the people that can be a respondent. If your party does not participate, there's nothing you're looking for there. If you don't win, there's nothing you can do there as a respondent, as the case may be, right? Furthermore, we're looking at what are the grounds that you can come up with for an election petition, right? Which is what I was, I kind of mentioned it earlier when I was talking about the when I was talking about pre-election matters and post-election matters, right? What followed under them. So that's something as the grounds. So we can have a ground for disqualification. That is to say that the person whose election is being questioned, that is the respondent, was maybe at the time the person was not qualified to contest in the election. The person, which means the person should have been disqualified initially. Or secondly, you are saying that the election was invalid by reason of corrupt practices, right? And thirdly, to say that the respondent was not duly elected by majority of lawful votes. Say for instance, even in our last election, which of these grounds do you think the petitioner would have probably come under? Just any comments?
You would have come under person not duly elected, like that it was invalid by reason of unlawful votes.
Okay, that's great. And you also know that by virtue of the news and everything surrounding it, they can even come with the 3 grounds, because there were times where they were saying that he probably forged the certificate, because, or for you to be disqualified, there's some certain criteria that there's some certain qualification for a person to be duly elected. That is, the person must be a citizen of Nigeria. He must have been elected. For a person to be disqualified, must say that the person is not a citizen of Nigeria, or is not a citizen by birth. The person has been elected into such office at any 2 previous occasions, or is an undischarged bankrupt, or he has presented a forged certificate. And then there were issues as to the president presenting fake certificates in between. Do you get? So that might have been able to come under. They can also come under what? Invalid or reason of corrupt practices. You can say that there were so many corrupt practices by virtue of what? The whole looting of vote and every other thing. They're not being duly elected, about saying that some of the votes were rigged. So you can't justify to say that what the person has not inched the majority of lawful vote cast, right? It has to be the majority of lawful vote cast, which was what brought about, when they were trying to contest this part of whether the vote was whether he had the majority of lawful votes cast. That was when the interpretation of a particular section of the Constitution as to whether FCT is included or FCT is not included, and there were so many interpretations on the internet. So those are the 3 things that you need to pay attention to, because the question.
So that no majority of lawful votes cast, is it the 3rd one or is it the 2nd one?
It's the 3rd. So when you say that the person is not duly elected, it means that the person is not duly elected by reason of vote. The person was not duly elected by majority of lawful votes cast at the election. So it is not duly elected by majority of lawful vote cast at the election. Is that fine?
Yes, fine.
Okay. And also notes that where the candidate who won the election was not qualified to contest, the petitioner who claimed to have pulled the next majority of votes cannot be declared winner by the tribunal unless the fact of disqualification were notorious and within the knowledge of the electorate. Otherwise, if the facts were not notorious, the tribunal must nullify the election and order a fresh election all over again. What I'm just trying to say is that if the petitioner, let's say the petitioner came second. Now, last election, Peter Obi came second, and there was election, there were petition, and so let's assume that his ground was that the president that won was not duly qualified to win. Now the votes would not, or the presidential position would not automatically be given to him, because of, because he was the second person, unless the fact of disqualification was so notorious and the knowledge of that disqualification is available to all the electorates, to all the voters. If it is that so, if it is notorious and it's to the knowledge of the electorates, right? If the fact if it was notorious and to the knowledge of the electorate, then you can say that the second person can become it. But if it was not notorious and you can't prove that the electorate had no good knowledge of it, they will nullify the election and order a fresh one, disqualifying the person who should have been disqualified and put only the lawful people who should have been there on it. Is that fine? Can I go ahead?
You can go ahead.
Okay. So there are some basic things that when you are drafting an election petition, some facts must be pleaded, right? There must be pleaded, which is the fact that the election, it must be like, because it's like, when you do matrimonial courses and you're trying to say, oh, the law states that the only ground, there's only one ground for dissolution of marriage, which is that the marriage has broken down irrevocably, before you then have the different subs of everything that come under. So we all know that the general fact is either you say he's been disqualified, or he did not have the duly lawful vote, or there were conspiracies or corrupt practices. So when those are the main grounds, you must then plead some facts. Some facts must be pleaded. That is that facts as to maybe election did not take place in some polling units, maybe the election materials were not provided. Every other thing that you are claiming is the cause for you to say there were corrupt practices. You must state it. You cannot just say that, oh, they snatched box here or something. You must plead it, which was one issue. I remember that some people, the lawyers too, I know that I know I read a particular response to one of the election petition. I don't know whether it was this last election or the previous one, where I know that I read the respondent, and what the respondents majorly hinged on was the fact that the petitioner couldn't plead. The local government areas, could not state the votes, could not state all those particular details that must be pleaded. They didn't plead it, and that was the ground that they majorly relied on, because all those grounds are very, very important and very valid, that must be pleaded. And what are the documents that accompany? So please hold on. Please, I'm having a class and I'm the one teaching. Please, your ball bouncing. Hello, I'm sorry. Yeah. So documents that accompany the petition, that is the documents that you front load. You must front load a list of the witnesses the petitioner intends to call in proof of the petition, written statement on oath of the witnesses, and copies or list of every document to be relied on at the hearing of the petition. And it means that when you don't front load all these documents, your petition is not going to even be accepted by the secretary of the election tribunal, right? I'm trying to really pick out the important things that, there's this stuff as to the stages, procedure, and sequence of events, right?
Mr. Desmond, so we are not going back up.
So for procedures and sequence of events involved in election petition, the stages, we have the election stage. The election stage is to include the nomination, accreditation of voters, the voting, the collation of result, and declaration of result. Then we have the presentation of election petition. That is when the petitioner submits this election petition to the secretary of the tribunal with all the documents are meant to be front loaded and every payment is meant to be made. Then the tribunal then serve the processes on the respondents. After that, they enter their appearance within 21 days, and the petitioner may then file a reply to the respondent's reply within 5 days. Then there's a pre-hearing notice afterwards. After the pre-hearing notice, then there's the hearing of the petition, and then there's the judgment. It means that from the declaration of results to these judgments, all these presentation of election petition, service of the processes, entering appearance, pre-hearing notices, hearing of the petition, and the judgment, like we said earlier, it must take place within 80 days. 180 days rather. Must take place within 180 days. And the kind of prayers or relief that can be sought in election petition is either the petitioner is to be declared validly elected or returned, or the election should be declared not to nullify it. Is either you declare that I win, or you cancel the whole election. And you cannot ask for the two prayers at the same time, and every prayer must be sought according to the ground. Say for instance, if you say that if your ground is not duly elected by reason of not having majority votes, it means that your ground is going to be that what you are going to prove that you should be declared as the winner because you have put the highest number of validly votes. If you say that they should disqualify the person, it means that they're disqualifying the person. If you can't prove the proper grounds of disqualification, it means that what will happen is they'll just nullify the whole election and not declare you as the winner. Those are the two prayers that you can only ask for one. In the alternative, you cannot ask for two of them at the same time. It must be according to your grounds that you have distilled in your election petition. So I think these are the major important things that then what standard of proof in election petition matters. The standard of proof in election matters is the same thing as it is in civil matters, which is balance of probability. However, where there's an allegation of fraud or crime as it relates to the election petition, that allegation of fraud or crime must be proved beyond reasonable doubt, as it is in criminal cases majorly. Right? And I think those are like the most important things that I think you need to point out for you for election petition. We've spoken about the time, the days, the grounds, the jurisdiction, the court has jurisdiction for it. Then for the draft, please learn the draft. I won't lie, I did not like election petition. I gambled it when I was reading for my finals. I read it, I did not learn the drafts, and by special grace of God, it didn't come out, so I was lucky. So please just learn your drafts in between it very well. So I think that's all from me on election petition. Please, if you have any question, please let me know.
Thank you so much. So yes, goodbye, Michael. Thank you so much. So